Hello, my dear students. I am Dr. Manoj Sharma. Today, the topic of our discussion is economic theories of constitution and development. Capitalism and democracy. The economy and the constitution are at odds. The constitution, apart from providing rights, outlines the principles and procedures of government, which can be either more democratic or more elitist. This implies that people have a choice. The relationship between capitalism and democracy is rather complex. Those who gain wealth from the economy are in a position to influence the polity. In some cases, the polity is dependent on the economic system because of the influence of wealthy interests. However, stability and order are much needed for the operation of the economic system. For instance, assuming a self-policing market mechanism begs the question of how such an efficient system can function in the absence of a coherent or a sovereign legal system, and in the absence of legal system strong enough to enforce compliance. The whole debate led to the development of new field of constitutional economics. Now let us see economic analysis of law. Three approaches are used in the economic analysis of law: interpretative, normative, and positive. Positive theory forecasts the emergence of laws and the reaction of society to them. Interpretative theory applies normative theory to assess the efficacy of laws according to the diverse ideas of efficiency and distribution. Interpretative theory applies positive and normative theories to the interpretation of laws. According to Robert D. Cooter, taken together, these activities constitute the economic analysis of law. The economic analysis of law is much like the economic analysis of other activities such as international trade and industrial organization. Now coming to constitutional economics. During the 1970s, scholars developed a separate field of study called constitutional economics or constitutional political economy from the considerably older field of public choice economics. Constitutional economics emerged as a significant area of study in the 90s. It was not surprising that the institutional constitutional framework that governs politics took center stage in public choice discourse rather than everyday political choices during a period of widespread constitutional reform across the globe. That being said, the topic is not entirely new. Constitutional economics, in its broadest sense, is a crucial part of a wider movement to reinstate the classical approach. The comprehensive theoretical framework and reforming mindset that marked Adam Smith's vision serves as major sources of inspiration. James M. Buchanan and Gordon Tulloch's monumental work, Calculus of Consent, the logical foundation of constitutional democracy, provided impetus to the development of the field of constitutional economics. It must be remembered that the idea of constitutional economy finds seeds and can be regarded as the present-day counterpart to Adam Smith's science of legislation. This emphasis on constitutional economy reunites the economic, social, political, philosophical, and legal viewpoints that were previously studied as part of moral philosophy. It would be easy to label constitutional political economy as the economic analysis of constitutional law, which would be somewhat limited definition. There is no denying that analyzing actual constitutions from the standpoint of contemporary constitutional political economy is an intriguing exercise that could serve as a sort of litmus test for the applicability of this methodology. The study of constitutional economics, nevertheless, encompasses the economic analysis of constitutional law, but it goes beyond it. As stated, the debate regarding economic theories of constitution or the economic analysis of constitutions gained strength from the public choice theory of economics. The aim of public choice theory, a subdiscipline of economics, is to study taxation and public spending. In 1950, the public choice theory emerged, but it gained prominence when Buchanan was awarded the Nobel Prize in Economics in 1986. The concept of public choice extends the economic analysis of individual behavior in the marketplace to behavior of groups making collective decisions. Economists assume that people are primarily driven by self-interest when examining behavior in the private sphere. The primary motivation for individuals' activity in the marketplace, whether they are consumers, employees, is self-interest, despite the fact that most people base some of their decisions on their care for others. The underlying premise of public choice economics is that while actors in the political sphere, including politicians, lobbyists, voters, and bureaucrats, show a certain amount of care for others, their primary motivation is self-interest. According to Buchanan, the public choice theory replaces romantic and illusory notions about the working of governments with notions that embody more skepticism. The whole idea is to analyze the functioning of public law, that is, the basic constitution, from an economic theory perspective. Now, coming to constitution as a contract. Proponents of constitutional economics believe that the constitution functions as a contract that safeguards the profits parties obtain from social collaboration. It must not be lost sight of the fact that sociologists like Hobbes also emphasized social contract theories. Modern constitutions are referred to as contracts entered into by the people and aimed at self-regulation, while at the same time laying down checks and balances on the government powers and governing institutions. Now, coming to economic theory of constitution making. The constitutional economists argue that just like marketplace economics, there is an economic theory of constitution making. Tamer and Ali Kammer has referred to this. From the normative standpoint, the neoclassical theory presupposed that politicians acting in their altruism and goodness create constitutions that maximize the public interest. Several modern approaches, including the constitutional economic approach, have rejected this method. These methods have characterized a constitution as, among other things, an institution, a contract, and a regulation. The constitution is an institution that protects property rights, enforces contracts effectively, decreases transaction costs, and achieves a trustworthy commitment. The constitution governs all social relationships, functioning as a social contract. The constitution, as a regulation, redistributes welfare among interest groups by redefining property rights. The most fundamental component that initiates a relationship between political and economic processes is, in reality, the Constitution. The Constitution affects every actor and interest group in political and economic domains, giving them the ability to influence the process of creating new constitutions. Despite attempts by politicians and private organizations to alter the Constitution in order to further their own agendas, the document is nevertheless intended to maximize the public good. With the separation of powers serving as an effective check and balance, private interest groups may nevertheless be able to sway constitutions through legislation and constitutional amendments. According to Tamer and Ali Kammer, the authors of Economic Theory of Constitution Making, deviation costs, rent, and implementation costs are institutional constraints. A well-designed institutional setting represents the high cost of deviation, low rents, and high implementation costs, while a bad institutional environment refers to low deviation costs, high rents, and low implementation costs. This is consistent with the related literature and the conditions of the real world. Well-designed institutional components such as legal mechanisms, elections, information channels, and transparent democratic structures in a country increase the cost of deviation for the politicians from his commitment. At least in this institutional setting, it is possible that a politician will lose the next election when his commitment is not credible. Thus, the cost of deviation is high and rent is low in a well-designed institutional structure. The Constitution is a living and dynamic document, and therefore the enforcement, maintenance, and improvement of the Constitution bring into play post-contractual opportunism. Just like the marketplace, the interest groups try to tune the Constitution by way of amendment processes and making regulations under the Constitution to suit the needs of the interest groups. Therefore, various interest groups in a democratic polity governed by the Constitution must engage in bargaining and negotiation to modify the umbrella rules under the Constitution. Thus, the majority group or groups try to modify the umbrella rules under the Constitution ostensibly to maximize public goods but also their own interests. This process of bargaining leads to the alteration of the Constitution and the framing of subsidiary rules under the Constitution. There are various models for amending the Constitution. Some constitutions lay down a simple majority rule to amend all or any constitutional provision, whereas others lay down a very stringent method for alteration. In the third model, the subordinate rules can be amended by a simple majority, while the amendment of the basic structure requires a supermajority. This is achieved through checks and balances, such as approval by the two houses of the legislature, reference of the bills to committees ensuring a sufficient waiting period, and ratification by state legislatures. This makes the deviation cost from the Constitution high. From an economic policy perspective, these procedures also involve combinations, bargaining, and trade-offs. Stability is very important for economic development. The constitutions promote stability in the basic structure, make amendments to the basic structure stringent, and lend stability and facilitate economic development. By enforcing the stability of the basic framework, the Constitution discourages wasteful rent seeking. Furthermore, the stability and non-manipulative of the political system are necessary to ensure accountability. Further, it leads to predictability. To ensure economic growth, policy predictability and long-term planning are important. Further, the taxation policy should be long-term and avoid retrospective operation. Many constitutions in the modern countries prohibit the retrospective operation of laws, including taxation laws. Stability is a necessary but insufficient condition for predictability. The economic theory of constitution making takes into account the realities of modern-day governments. The supermajorities try to amend the constitutional contract in accordance with their economic model to maximize their interests. Therefore, the economic theories at play in the process of constitution making, amending, altering, interpreting, and enforcing the same assume significance. Now, coming to economic theories of constitution and development, it would not be correct to analyze only those parts of the Constitution that deal directly with taxes, monetary policy, or the revenue and expenditure powers of the government under this topic. This would be a very narrow outlook. Instead, constitutional economics is a much wider field and covers other constitutional matters dealing with rights, directive principles of state policy, federalism, separation of powers, taxation and expenditure powers, constitutional democracy, etc., which have a direct and indirect impact on constitutional economics. Now see efficiency and security. Modern constitutions try to strike a balance between security and efficiency-oriented theories while dealing with social and economic justice. Whereas the aim of governance under the Constitution is generally to secure efficient use of the material resources of the country to promote efficiency and ensure maximization of wealth. At the same time, the security needs of the most vulnerable are also required to be taken care of. The modern constitutions, therefore, provide for taking care of the well-being of the worst of members of society and ensuring that the vulnerable populace has access to the basic amenities for their survival. Though income transfers to the vulnerable populace lead to compromising efficiency criteria, this is important to ensure security needs. There has been an increased emphasis on ensuring economic justice by maximizing wealth, subject to ensuring that no one is below the state-determined poverty line, that is the floor level of income. Now, coming to democracy, the constitutional laws across the world have increasingly favored the adoption of democracy as a system of governance. Democracy is the result of social contract and the constitutional contract. The adoption of democracy vests in the majority the power to bargain for the maximization of public goods. The interaction between groups constituting the majority and minority shapes the economic and other policies of the government. Unlike dictatorship, where long-term economic goals can be better planned and implemented, in a democratic setting, it is difficult to implement long-term economic goals, providing opportunities for bargaining and opportunism for the political actors. Researchers have identified accountability as a crucial factor in economic growth. The democratic system of governance has the ability to facilitate this. Accountability affects both economic efficiency and security. If the executive is not subject to sanctions, it cannot make credible promises. Furthermore, if those responsible cannot be held accountable, threats to basic security may not be deflected. Democracy assures that the elected government is accountable to the legislature and ultimately to the people. Scholars claim that constitutions adopting democratic forms of governance have developed faster than others, often citing the example of the United States of America, to establish a strong correlation between democracy and economic growth. Another factor, separation of powers. Modern constitutions adopt the mechanism of separation of powers for bifurcating governmental powers among various organs of the government, partly to ensure functional division of labor, partly to protect against corruption and bribery, and partly to provide a system of checks and balances. The separation of power theory from an economic standpoint proceeds on the supposition that division of labor leads to the development of expertise, and consequently, one group focuses on performing only one set of functions. Thus, the separation of powers theory divides the governmental functions into three organs: the legislature enacts the law, the executive implements the law, and the judiciary interprets the law. Locke, in his writings, examines the contours of the separation of powers. He wrote, "It may be too great a temptation to human frailty, apt to grasp at power, for the same persons who have the power of making laws to also have in their hands the power to execute them. Where they may exempt themselves from obedience to the laws, they make and suit the law, both in making and execution, to their own private advantage, and thereby come to have a distinct interest from the rest of the community." A renowned economist, Adam Smith, said, "The separation of the judiciary from the executive power seems originally to have arisen from the increasing business of society as a consequence of its increasing improvement. The administration of justice became so laborious and complicated a duty as to require the undivided attention of the persons to whom it was entrusted." Now, coming to the model of governance. The constitution-making process in the 19th and 20th centuries experimented with various economic models of government. The constitutional theory determines whether to follow a restrictive or easing out monetary policy. The theory underlying the Constitution determines whether it envisages a socialist, communist, capitalist, or mixed pattern of governance. And accordingly, the Constitution influences the adoption of appropriate economic and monetary policy. Under the communist model, private properties were not allowed initially, and the primary focus was on maximizing the public wealth. The capitalism model recognized freedom of trade, commerce, and intercourse, freedom of contract, and socio-economic and political rights, wherein the maximization of wealth remained the focus. A mixed model, on the other hand, provides leverage for balancing the capitalist and socialist models. Therefore, the model of government adopted in the constitutional contract determined the dependence of economic policy. Now, coming to the system of governance, modern constitutions increasingly embrace federal governance, where national and subnational governments share powers and functions of governance. The economics of federalism proceed on shared responsibilities and maximization of revenue generation by labor gains obtained from efficiency achieved by subnational governance and expertise. The federalist structure promotes competition among national and subnational governments on one side and amongst subnational governments on the other. And it promotes interaction and bargaining among various political actors at the national and subnational levels. In a federal system of governance, the Constitution bifurcates the powers of the government regarding taxation, revenue generation, and expenditure responsibilities among the national and subnational governments to promote autonomy and efficiency in governance and revenue generation. Tax and economic policy in a democratic federal polity, therefore, are dependent on various actors at the state and federal levels, making the bargain more complex. Now, coming to rights and freedoms. Generally, democratic constitutions enacted by a social contract guarantee rights to people, including the freedom of contract, the freedom to carry on trade, commerce, profession, business, the right to property, and other economic, political, and social rights. These constitutions also provide for freedom of trade, commerce, and intercourse throughout the territory of the country. The USA, Australia, and Indian constitutions are the prime examples of this. The right to property and the freedom to enter into contracts are important enablers of economic growth and for ensuring economic justice. For efficiency to have an economic effect, it often requires pre-commitment, which necessitates endowing citizens with effective political rights to be credible. The constitutions providing for social rights, the right to work, the right to health, and the right to social benefits may have varying impacts. On the one hand, the constitutions increase the security needs of employees, but some claim that they also raise the cost to the employer, resulting in reduced employment in a regular cadre. Various social scientists have tried to analyze the economic effect of constitutionally guaranteed rights and their relationship as follows. Social rights promote economic security. Economic rights promote economic efficiency. Social rights undermine economic efficiency. Economic rights undermine economic security. So there is a complex relationship between social and economic rights guaranteed in the Constitution and economic efficiency and development. Some argue that the right-based approach adopted in the Constitution is not merely a legal theory, but rather an economic theory. Now let us see the economic theory of the Indian Constitution. The Constitution of India is the basic norm, that is, from which other laws derive their source and strength. The preamble of our Constitution begins with "We the people," reflecting the public choice theory that demonstrates a social contract among the people to collectively govern themselves through the Constitution. the preamble provides that India shall be socialist, democratic, and republic. The framers of the Constitution therefore adopted a socialist pattern of governance, where governance shall be by elected representatives, that is democracy, and all citizens, including the majority and minority, shall have equal rights. The Constitution therefore explicitly ensured that the material resources of the country are not concentrated in a few hands, but rather used for the inclusive growth of all without discrimination, irrespective of caste, creed, religion, sex, etc. Thus, the Constitution adopted the economic policy of inclusive growth. The matter becomes further clear when we glance through Part 4 of the Constitution, which contains directions to be followed in state policy. From a governance and policy perspective, these principles hold great importance, even though they cannot be enforced through the courts. The provisions contained in Part 4 clearly provide for the adoption of welfare economics to ensure not only social and political justice but also economic justice. See Article 38. The Indian Constitution has adopted various economic theories and doctrines such as the separation of powers and a rights-based approach that guarantees various rights, including freedom of contract and the right to property. It also includes stringent provisions for amending important parts of the constitutional provisions. Now let us conclude. Constitutions are modeled on the basis of identified economic, political, and social theories, keeping in view the contemporary problems and challenges. Contemporary socio-economic approaches and challenges affect the making of the Constitution, and the Constitution in turn profoundly impacts the economy. Not only written constitutions but also unwritten constitutions and conventions shape the economy. An unwritten convention in the United States of America grants the Federal Reserve Board, the central bank, freedom despite it being not written in the Constitution. Similarly, Indian law also provides for the freedom of the central bank, which is the Reserve Bank of India. We understand that the freedom of the central bank is very important for ensuring smooth economic policy and keeping political interference at bay. Robert Cooter opined, 6 processes make and sustain constitutions: bargaining, voting, delegating, entrenching, adjudicating, and enforcing. Economic theory illuminates these processes and constitutional law reflects them. With this, we come to the end of today's discussion. Thank you very much.